Hello, everybody. You are tuned into Nong. My name is Nong, and my name is. Today we have an awesome guest, man. Always love having this lady on. I call her our sister-in-law, and you'll understand why in a couple of seconds.
Good morning, everyone. My name is Phateka Maliphale, a director at PP Maliphale Incorporated. Thank you for having me, guys. Thank you for this platform, Nongwealth.
Speaking about really important questions where because a lot of times we're having a conversation with this pet about this is that especially when it comes to property invest or as assets as a whole, having assets, and then how does that actually affect your relationship not only with your spouse, however even with your testator. Like, I'm learning so much. As you can hear, our English is actually at that level thanks to this pet, man. It's quite on a legal level. So let's get into questions that will be affecting you and how can you position yourself when it comes to acquiring assets and positioning yourself when it comes to assets such as your properties and having a will, the importance of having a will. Most definitely. So now, suspect, man, with being a lawyer in property, there's always this word that actually comes through, and they speak about bequeath. Can you please just speak about bequeath and then what happens when you do not bequeath an estate?
Thank you so much, guys. Firstly, I would like to mention that in terms of our South African law, the freedom of testation is recognized, that is subject to a valid will. So freedom of testation is when you give your assets to someone, is when you dispose of your assets. So a person may make a will directing how his assets shall devolve after his death. So, meaning, how would you want your assets to be distributed after your death? So, we then call that person has died testate. So, meaning that person has left a valid will. So, there is a certain act then that applies, which is a Wills Act. It takes application. And then, when a person then dies without leaving a valid will, then we say that that person has died intestate. So, meaning there is no valid will in place, and then the act that applies there is an Intestate Succession Act. So when we talk about bequeath, we are saying you are leaving something to someone or you are giving something to someone. So we then in our legal terms then say that you have bequeathed a certain asset to a certain person in terms of your will.
I'm actually happy that we spoke about this. I remember having a conversation with my parents earlier on this year, and I was telling them that there's a high possibility, not there's a high possibility that I do want to get married out of community. And then they were like, what? What's this guy saying? Even when I told my mother, she looked at me as if I'm crazy. So these are the topics that we're supposed to be having, and how we better understand how everything operates from the assets that we've accumulated, because I know that we work so hard, we buy so many things, and then how is this actually going to affect the future generations to come? Because we always speak about acquiring generational wealth, but when it comes to the will, do we actually sit down and truly understand that? Like, personally, I always have a conversation with Lebo. I'd like all our viewers to think about this, that I would rather pay school fees in terms of support Miss Pet, get her on board before anything goes bad, to avoid a whole lot of things at the end. Because as unfortunate it does sound, that it is going to come a point in time whereby our time will end. So how will we actually continue with this thing called generational wealth? So I'll say that you better pay school fees right now than pay later on. So Sis Pet, another question that we have for you is that, can a will be declared invalid?
Yes, a will can be declared invalid, and there are actually few or various reasons why a will can be declared invalid. And the first one is if it does not comply with the formalities of the execution of a will. So if we're talking about formalities, then we're talking about the will is in writing. We're talking about a will has been signed by the testator, that is the person who disposes of his assets. So if for example a will is not witnessed by two witnesses, then if maybe it's signed, a will is signed by the testator using a mark, and there is no commissioner of oath who satisfy that that will was actually signed by the testator himself or herself, and then maybe the will was executed, because sometimes you find a will where it's dated today, and then the following day the witness is signed. They are not signing on the same day, because one of the formalities of a valid will is that a will must be signed in the presence of two witnesses as well as the commissioner of oath. So those are the various reasons that a will can be declared invalid. I know that a high court does come into rescue in terms of trying to get to the compliance of those formalities, and people do run back to court, so that the court, if the court finds that no, the will is actually invalid due to whatever reasons that the court might find, so that they can be able to direct the master of the high court to accept the will. So those are the few reasons why a will can be declared invalid. For example, a lot of people, they sign a will like differently. The first page someone put a name, the second page you put initials, and then the last page then you put your full signature. So meaning there is no consistency in terms of how you are signing the will. So those are the reasons why a will can then be declared invalid. But again, if one does approach court, then court might look at it in a different way. But then again, the onus then is on the person seeking validity to prove to court that it is indeed a valid will.
Someone has the will, right? And everything is done, everything is signed. So now it's we at that process. I think you as an attorney can actually put it correctly, but I will run away from someone from saying that someone died. So now let's just say that the will is now needed to actually work. So now, can someone be actually disqualified from the will, or they do not actually benefit from that particular will? So now, if I have actually left my kids with all of my properties, can they actually be disqualified from the will, or not actually inherit the will that I actually had written down?
When we talk about disqualification or disinheriting, a testator has a freedom to dispose of his assets, right? And you can choose, for example, if you want to disinherit a certain child, or maybe disinherit a spouse. But again, it's something very broad, which means that if for example you are married in community of property, you cannot just leave, or maybe just decide that you are going to exclude your spouse, because remember the assets are joint assets. And again, if you decide to leave a child out of your own will, obviously there are various reasons, because remember, when you leave a will, you are putting out your wishes, and if your wish is not is for a certain child not to inherit, then that child can be excluded. But then again, it doesn't mean that the child cannot come back and claim maintenance from the estate. So when we talk about disqualification, then we're talking about, for example, where someone has signed a will as a witness, and yet he's mentioned in the will. Sometimes it does happen that that person gets disqualified, unless then the court can prove otherwise. And secondly, on disqualification, when someone has influenced the testator to be given a benefit in terms of the will, then that person can be disqualified. Or if maybe someone has is the cause of death of the testator, then someone can be disqualified. And then again, people can go back to court to try and lodge an application for that, so that they cannot be disqualified. Again, it will depend on how the court views the disqualification. So So disqualification and disinherit is when the testator decides that he wants to exclude a person from the will. But then again, that has got some limitations, because if it depends again how you are married, and then again the person who's excluded, it doesn't mean that that person cannot go back and claim for maintenance from the estate.
Wait, suspect. So now what you're saying is that if I have actually written down a will and I do actually pass on, is it possible for my kid that I didn't actually put in my will go to court and claim that they need a certain portion of my estate for maintenance?
Yes, you can submit a claim for maintenance to the attorney who's administering the estate. Sometimes it happens that someone leaves a will, but it doesn't deal with all the assets that he owns. So meaning that some assets, they will be dealt with according to what is stated on the will, and some assets will be dealt with on what is called intestate. So meaning we're dealing with those assets as if there is no will, because those assets are not being listed in the will. So then in that case, such a child can be able to inherit, because in terms of those assets that are not part of the will, then the assets, they will be dealt with as if there is no will, which then the child who was excluded can maybe be able to inherit from those certain assets that are not forming part of the will.
No, that's really interesting, because now I know that when someone did actually pass on, you actually need to advertise on I'm not sure if I'm using the right word, but something like advertise on the newspapers that so and so has actually passed on, and then if any claims are there,
Yes.
then they can actually go and claim at that particular at the
And submit their claims. That is correct.
No.
That is correct. They can.
Sure. That's I mean, I'm thinking about it right now, and I'm thinking that if someone does actually have, I mean, this it's a taboo. A lot of people don't want to speak about this, but now it does happen that men and women have children outside marriage, and these children aren't actually known about. So now it becomes a shock when now the guy has actually passed on, and now this child from somewhere we've never seen them, and they actually come through and they're like, yeah, he was also my father, so I'm also entitled to actually a portion of their particular share. So now, is it then shared accordingly if that person isn't really in the will, or is it only shared according to what's in the will? Or are they going to say that, you know what, I see that there is a will, but now because all four of them are siblings, we need to divide it equally?
Yes. Remember, if there is a will in place, so the assets are being dealt with according to the wishes of the testator. So we cannot, for example, say that the child who's coming from somewhere has a right to inherit if he's not being mentioned in the will. So the child must be mentioned in the will, unless then if the child would want to submit a claim for maintenance to the attorney who's administering the estate. So if you wish to do that, then you can be able to submit such a claim. But we cannot say that you have a right to inherit your father's estate if your father has left a will and you are not being mentioned in that will.
No, I'm very happy with what you mentioned. It goes back to how we started this topic, that you cannot run away from not having a will, because at the end of the day, it will just make things more complicated. So it goes back to the school fee scenario that I would rather call Sis Pet. We will leave her details down below, or you can actually reach out to us. We'll be more than happy to link you with her. Sort your things out while you're still alive and kicking,
to avoid a mess after that. So I have another question, Ms. Pet, right? I want to understand the influence of the value of the estate on the administration process. What influence does the value of the estates? Because somebody might think that maybe my estates combined together, it's below 250. What's the difference between that 250,000 compared to somebody who has something like a 3 million to 8 million?
Yes, it does have an influence, because if an estate is 250 and less, The submission of the reporting documents to the master when you're reporting the estate, they are the same documents, but then the master can issue a letter of authority for any estate that has got a value of 250 and below. And then if the estate has got 250 and above, then the master of the High Court issues what you call a letter of executorship. Now, the difference with these two letters is that the first letter, which is the letter of authority, it actually renders you to a shorter process. So meaning you are not required to open an estate account, you are not required to advertise the estate, and you are not even required to draft a liquidation and distribution account. So when you then receive the letter of executorship, meaning your estate is more than 250, then you have to take the longer process whereby you have to administer the estate by advertising, by opening the estate account, by drafting the L&D account, all that process, which is why a lot of clients, they always ask themselves, why is the administration of estate takes longer? They are forgetting, because sometimes we'll compare your situation with the other person, and the other person maybe has a letter of authority, and that person was then not required to administer the estate using the long process. And then yours is different in the sense that we have then to deal with it by the way of administering the estate using the long process. So in that case, then on all those adverts, because you have to do, for example, 2 adverts whereby you're advertising for creditors, and then again the second advert you're advertising for the liquidation and distribution account. That is then before the assets of the estate can be distributed. Then that's actually the end. And unfortunately, because we have to deal with the master of the High Court, and each and every step that we take, then each step has to be confirmed, or the master has to consent or give you a direction to be able to move to another step. So that is why it usually takes longer.
Just to follow up on that, right? Let us just say that there is a family out there, they had more plus 250,000 combined together, and then let's just say the person passed on, and then now the lawyer is actually taking too much time. Let's just say then that lawyer is not even telling the family a right story in terms of this is where the process is. So the family actually find themselves that we do not understand what's happening with this lawyer, because this attorney is not getting back to us in terms of where is the process, and it might, let's just say it's on year 2 already, so they might be panicking that what is happening. So how can that family go about that? Because I understand with what you said, if it's below 250, there's not so many processes. However, if let's just say it is above 250 and the family is panicking, whereby we feel as if there might be something wrong with the lawyer, how do they go about that?
It is actually important for clients. First of all, I would like to mention that if you want to appoint an attorney to administer your estate, appoint someone who actually has some knowledge on the administration of the estate. Because sometimes we go and approach, I would say, for example, a criminal lawyer, and a criminal lawyer doesn't do administration of estates, and obviously he's still figuring out how to deal with that estate. So it's important to appoint someone who has the knowledge of that field. And secondly, coming to us as lawyers, it's important on the very, very first consultation with the client that we then explain to the clients that the process, how is the process going to be. And sometimes it does happen that on that first consultation with a client doesn't disclose everything. For example, a client doesn't disclose all the assets, or a client doesn't disclose all the beneficiaries in the case maybe there is no will. And then the process then takes longer, or there are delays due to the fact that whatever that you have reported with the master is actually incorrect, because you have to rectify that. But then the most important thing is make sure that there is a communication between yourself as well as the attorney that you have appointed, because attorneys duties are to make sure that the clients are kept up to date in terms of the processes, and then again try and explain the process to the client in a very simple way, or in simple terms, where the client will be able to understand exactly what is the process going to be and how long the process is going to take, because sometimes trying to avoid the frustration from the client, it's better to just spill the beans out at a very, very beginning, that this is what is going to take, this is how some estates, they can be complicated, but it's important to try and explain to the client from the onset that this can take long and why it's going to take long.
Sure. Suspect, I'm always thinking about the money side of it. That, say for instance, this person has actually handled everything of mine. However, I'm seeing that this person is actually taking around 2 years and there's no communication between myself and this person. Am I still liable to actually pay them if I want to actually use a different lawyer? So now, say for instance, I have a lawyer that I've actually appointed and now I want to appoint another lawyer. Am I liable to pay this lawyer that this person hasn't actually been communicating anything with me, and when I do call, he's telling me that, there's just something wrong with the other thing, but when I do give him that information, he tells me that no, there's something wrong with the other information. Am I liable to pay that lawyer, or can I just switch lawyers, ask for all the things that he's done, and then switch lawyers?
You know what, you are allowed as a client to switch lawyers, but I must mention that the other lawyer obviously has already done some work, and that lawyer can then be able to charge you the wasted cost, so meaning the payment for the work that is already been done. So that is not a problem, because we do, for example, get instructions where some lawyers have already started the process, but because of the client's frustration of the process, then they decide that, you know what, I'm cutting ties with you, I'll go with this other lawyer. So that other lawyer then, before transferring the documents to me, for example, then they would want a payment or an undertaking for a payment for whatever portion they have done in terms of the process, because lawyers are allowed to charge for wasted costs. But in terms of you as a client changing attorneys, yes, you can do that, but obviously with the communication with that, because for my side, for example, I won't be able to just take work that is coming from the other attorney without understanding what actually transpired in terms of why the client decides to change and appoint someone else.
Makes sense. Makes sense.
So now we have the last question, Sis Pat. We have the last question, and the question is that, am I able to actually amend my will? And if so, how long can I actually should I actually wait before I amend the will?
Yes, amendment of the wills actually is very important. So a will must be reviewed regularly, and more importantly, whenever there is a change of a person's status. So you are now labeled unmarried, you have your own will, dealing with your own assets the way you wish, and then now you decide to get married. Obviously, you can't have that will. That will is still valid. It doesn't mean it's not until it gets amended. But you do not want a situation whereby you have a will and then your spouse is excluded in terms of that will. And then again, depending on how you married, obviously. So a will must be amended, especially if there is a change on one's status, where there is a marriage, where there is a birth, for example, there's a new child, and where there is divorce. So it's again important that when you get divorced, you make sure that you change that will, because you wouldn't want your ex-spouse to inherit you, to die within 3 months from date of divorce.
Sis Pat, what you mentioned right now, we might laugh about it. However, it's something serious. Imagine forgetting to amend the will, and then you marry again, and then something happens to you. I'm sure this has happened before, and it will still happen. So to avoid this again, I'm directing you to pay school fees with Sis Pat. We are going to have her details. I'd rather do that now than later, guys. So if you don't want your ex, wife, or husband to get your hard-earned cash and goods, consult.
So now, Suspect, can you please just tell us about something interesting that you actually told us about the Will Week?
Yes, the National Wills Week, guys. It is from the 13th to the 17th of September. I have registered myself to be assisting clients who wish to draft their own wills. It's always recommended that you have your will drafted by a professional person so that you make sure that you do not have a will that will be declared invalid at a later stage. The National Wills Week allows clients to approach attorneys where the wills are drafted for free. And the drafting of the wills for free then obviously just depends on the amount of time that has to be taken in terms of assisting the client, but the wills that we draft in terms of that week, it's for free. So we can consult for free. You can talk to me for free in that week and ask me whatever questions.
Only for that week.
Yeah.
Only for that week, suspect.
From the 13th to the 17th of September, yes.
Suspect, there's actually something that I actually heard from someone, right? They said that, is it possible for an affidavit to act as a will?
Yo, you know what? I would say no, but obviously I might know with a question, exclamation mark. Because again it depends, because people can go back to court and try and see if maybe court can't view it differently, because an affidavit is an affidavit, a will is a will. So there are so many issues that can be considered by court, like the heading, like some certain clauses that have to be on the will, where you have to do a revocation clause, for example, where you're saying you're revoking all the previous wills, and it must just be the intention of the person who writes the affidavit was intending to make that affidavit his will. So there are so many things to consider. For me, that is why I'm saying the answer is a no and a yes. So depending on what the court will view it.
So hope you guys did get so much value out of this. Personally, we got a lot of it. Every time we speak to Ms. Pet, we know for sure that we learn so many things from terminologies to the law side of life and actually counseling. We know that every time you get into marriage, or even when you get out, you need to consider your will.
I was teasing Suspect that Suspect should actually consider saying that she's also a marriage counselor.
Yeah.
But under the assets there.
No, I truly believe you can't get into marriage without discussing the asset side. That's most of the times we have actually turned a blind eye on that. However, it always comes out, even though it might not come out ugly in terms of divorce. However, it can come out ugly in terms of people fighting for the assets. So you'd rather prepare yourself by knowing what you're truly putting yourself in beforehand.
Sure. Nice having you, Suspect, and until next time.
Thanks.
Cheers.
Yes, guys, thank you so much for the opportunity. And yes, in closing, I would just mention that, guys, please, even if you decide to do a will with someone else or whoever who is not a professional person, please make sure you understand the formalities, and you do not want a situation where your wishes will actually not be your wishes, because at the end of the day, when the will is declared invalid, then it means that your assets will not be dealt with according to your wishes.
But I'm biased. Sorry about that. I'm biased. Not even somebody else or whoever. Suspect. Like I would recommend. I would put my head on the block with the service that you provide. So I wouldn't say that they must go to somebody else. I'd say that they must come through you and support me.
Sure.